Welcome to today's webinar on the 2024 revisions to the EPA's Risk Management Program rule. I'm Stephanie, your host for today's session, and I'm thrilled to have all of you with us. Today, we'll be delving into the recent changes. While this update will further protect vulnerable communities from chemical accidents, it may have a major impact on any of the nearly 12,000 sites covered under the rule. The EPA officially published this new rule on March 11th, and it takes effect on May 11th. So no matter where you work or your involvement, we're here to offer insights for sites affected by the rule. Before we begin, I want to encourage all of you to actively participate in today's session. We value your questions, so feel free to submit your questions throughout the webinar using the Zoho webinar Q&A box that you'll see here. We'll be addressing your questions during the Q&A session at the end of the presentation. We will also be recording this webinar, and we'll make the recording available to you in the next couple of weeks. And if you'd like a PDH certificate, please email us at contact@acutechconsulting.com after the webinar. I'll have this email address up on the screen at the end. Please note that the opinions shared today are only the opinions of the presenters and not providing any technical or legal advice. So now let me introduce you to our speakers who will be guiding us through today's topic. We have Mike Hazzan, a senior principal engineer here at AcuTech. He is a CCPSC with over 45 years of experience in process safety and risk analysis, security, engineering, and plant operations. He's authored or co-authored several CCPS guidelines books on process safety auditing, process safety culture, security, and contributed to the books on inherent safety and mechanical integrity. We also have David Moore, founder, president, and CEO of AcuTech Group Inc., who has over 40 years of specialized experience in process safety and risk management. Mr. Moore's expertise includes the management of process safety and security, PHAs, quantitative and qualitative risk assessment, OSHA and EPA compliance, process safety engineering, fire protection engineering, and emergency planning. And finally, we have Mark Farley, managing partner of Farley Partners, a preeminent national workplace safety and crisis management lawyer. Mark has served in lead attorney roles for some of the most significant U.S. industrial accidents and transportation incidents in the last 20 years. Mark and his colleagues also counsel clients on chemical accident prevention requirements, including the EPA Risk Management Program regulation. All of them bring a wealth of knowledge and experience in the field, and they'll be sharing their experience and insights with us today. So I'll now pass the virtual microphone to Dave, Mike, and Mark to kick off our webinar. Dave?
Yes, good afternoon to everyone. We're pleased that you're choosing to be with us today for this important topic, and we hope to make this informative. Obviously, a significant event occurred here recently where EPA released this final rule. It had been a long time coming, and we fully anticipated most of this, but now we have to actually face the final language and the implications of the rule. So we've done an analysis of at least 6 key elements here, and we'd like to go through each of them. And the format would be that we're going to have a conversation with you. If you're willing, you can give us questions in the Q&A, and we'll go through some of those, particularly at the end. But Mike and I are going to discuss our insights to what we believe are key points and issues that you should be particularly aware of, particularly of the most significant changes that are going to cause the most work and bear potentially more risk to you, particularly regulatory risk. And then Mark is, we're pleased that he's here with us. He's certainly an expert on all of this and would like to have his insights as he's been tracking this for some time as well. He can talk about regulatory compliance and strategies for that, and also legal implications. Mike?
Okay, thanks, Dave. The first technical issue we want to talk about is a new requirement to analyze natural hazards in your PHA. And this is based on the government's overall look at climate change and how climate change may affect risk in general. And how that trickled down to the RMP rule is the EPA identified different types of natural events, or they analyze certain types of natural events, and are now requiring that the PHA component of the RMP include an analysis of those. and what the triggering events could be that would make an accidental release worse because of the ambient conditions. Now, what they didn't do is they did not require, and this is important, that anybody regulated under the rule conduct their own climate research or interpret climate change or do any of that sort of basic first principle science kinds of things. They just require that you analyze natural hazards in your PHA. They also did not specify any physical changes to the plants, any additional safeguards, if the PHAs reveal that the facility is vulnerable to one or more natural events. So currently the requirement is that you analyze these events in your PHAs. Next slide, please. So what do we think, how do we think this is going to play out? You have to document in your PHAs in some way that you've included such events. Now, since EPA didn't specify which events each facility had to analyze, each facility, each company is going to have to determine what those are, or establish the criteria for selecting them if it's not clear. The most likely approach, the one that seems to have been used over the years, where many facilities have looked at this already on their own, is to use checklists or use a global node in their PHA. Some approach like that. We think, at least right now, that will be acceptable. We're hoping it will be. They did not specify any special type of analysis, nor did they specify that you do something quantitative beyond what your PHAs are already doing. Additionally, in the preamble, EPA sort of framed this issue as is pre-existing. It's an amplification of a requirement that they thought already was in the RMP rule, that natural events can be contributors or causes of process safety events. And this is now just a formal recognition of that. Next slide, please. One additional input to this whole natural events issue is some work done by the General Accounting Office of the government. They published a study in February of 2022 where they looked at the distribution of RMP facilities and areas in the United States that were vulnerable to natural events that could be triggered by, possibly triggered by climate change. And what you see here on this map is a whole lot of green dots across the landscape there. Those represent about 31% of the total RMP community. So, roughly a third, EPA believes, and GAO believes, roughly a third of the current RMP community will be affected or could be affected by one of these natural events. Next slide, please.
Let me just jump in for a minute, Mike, and
Sure,
talk
go ahead.
about that issue of amplification and why it matters. What the agency is basically saying is that the requirement is already in the existing rule, but now they're simply making it explicit. As I'm confident folks know, especially those of you on the Gulf Coast, there have been some high-profile accidents associated with natural disasters as the initiating event. The incident at the Arkema site in 2018, for example. And so since then, and because of the focus that at the time the Chemical Safety Board brought to that issue, we've started to see EPA already pressing for owners and operators to consider these issues in the context of their PHAs. The fact that it's now explicit, again, from the agency's perspective, there's no excuse not to do it, but recognize that inspectors may not show a lot of patience if you aren't doing this because of, again, this agency perspective that somehow the rule has already allowed this, just given the elastic nature of the RMP requirement. Thanks, Mike.
Oh, thank you, Mark. Good point. Okay, next slide, Dave, please. Okay, the next issue is also an impact on the PHA, and that's loss of power. As Mark just noted, there have been some fairly high-profile events in recent years that have involved loss of power, just like there have been some involving natural events. Some of them are combined. It's a natural event that creates a loss of power. But in any case, an analysis of the loss of power must be explicitly included in the PHAs. The PHAs have to look at standby or emergency power systems if you have them. There is no requirement that you provide them if you don't, but if you do have them, that must be part of the analysis as well. If you find that you have a vulnerability, then they're going to require that you lower that vulnerability or lower the risk in some way. Again, they did not explicitly say that you have to have an emergency standby generator or anything like that, but you are required to reduce the risk from loss of power. They did require, and this is an explicit requirement, that air pollution control or monitoring equipment, such as the fence line monitors that you have for environmental release or environmental emissions purposes, must have backup power or standby power. Those are devices that would probably be one of the first indicators of release of an RMP regulated substance that is then going to cross the plant boundary into the public domain. So those devices do require, based on the new rule, that you have standby or backup power for them. Again, I already said this twice, but I want to stress it. There is no explicit requirement in the new rule to provide emergency power systems. Now, how do you do this in your PHA? Again, a common approach that's seemed to be successful in the past for some companies is to use checklists, use a global node in their PHAs. Those are two approaches that we think will suffice. Again, there was no special analysis, nothing quantitative specified in the new rule. You should look at the reliability of your existing power supply systems if you have them. So the inspection and testing of them, the functionality of them, this is something that you should pay a little more attention to.
Just to echo what we talked about around natural hazards, here again, I think EPA would say this is something that has already been or should have been part of the PHA. We've actually worked with companies that have been the subject of EPA enforcement on this particular point, especially in jurisdictions like California, where there's a tremendous amount of scrutiny on the flaring that results from power losses. EPA really has approached those flaring events as if they are a chemical accident or a chemical incident, as opposed to the actual operation of a safety device, and has then really post-flaring pushed on whether or not the PHA for the affected units considered sufficiently the issue of power loss and the consequences of power loss. So I would expect to see that type of scrutiny now on a broader basis.
Okay.
Yes, thanks. Another requirement that was added is the most expensive one. If you read the cost analysis associated with justifying the regulation that EPA had to do, they claim this is more like 70% of the costs that they expect for industry would be the conduct of this and the efforts involved. I personally believe that may be a severe understatement. But what this means is a safer technologies alternatives analysis, or STAA. It's somewhat of inherently safer technologies or inherently safer design alternatives, as the industry calls it, that have been talked about for a long time. As you know, this concept really originated in the late 1960s and is condoned by industry, but mostly is voluntarily used and sporadically used. It has been required in Contra Costa County in California, which we're very used to from our work there, as well as with the Toxic Catastrophe Prevention Act in New Jersey from our work there. But this is now, national. So this is going to impact some people more than probably a lot of the other aspects, depending on what they do. For example, they based the requirements primarily on NAAQS codes 324 and 325. And the justification for that was the incident experience was said in the preamble. They also are saying if you're co-located within 1 mile of another RMP regulated facility, you might say, well, how would I know? Well, that information is publicly available. So you'll have to determine this, and that's fence line to fence line, which might involve in dense areas, almost an automatic, yes, I have to do this. The other aspect would be that they absolutely said that if you're in 324 with hydrofluoric acid as an alkylation unit, so that you're a petroleum refinery using it as a catalyst in an alkylation unit, then you must do this. This represents around 45 refineries in America. And thirdly, they said if you've had one accident, in accordance with the definition of what is a reportable accident for RMP, which did not change, then you must do this as well. So some of the requirements are that they consider this part of the PHA process. The PHA process is all the activities that you have to do, the planning, the participation, the sessions, the reports, the follow-up, etc. So now what they've done is they've added the requirement to study, at least in those cases, STAA. And what does it really mean? If you're familiar with inherent safety, there's 4 key strategies and up to this point, it's with the exception of a couple of regulations that I mentioned, it's been voluntarily done, and some companies do this as a matter of course. Companies that have not entertained this, have never done this, are probably up for more work than those who have incorporated it for some time in their workflows. You have to include at least one member who works in the process and has experience in the process being evaluated, which is nothing particularly new. You have to have, in addition, what's called a practicability assessment. This means that you have to be aware, first off, of alternatives, and you have to, when you identify at a process that there's a hazard and you say, could an inherently safer solution be applied, then you have to identify the options and why didn't you select this? So if you absolutely say this is not something that we either want to do or can do, you would have to describe why is that. And there is the probably $1 million question, is how much is enough there to describe a negative and justify it. And by practicability, they're talking about, as they say, the capability of one of these measures, either an inherently safer technology or design, to successfully accomplish within a few parameters, reasonable time, accounting for technological, environmental, legal, social, and economic factors. The mission being to reduce the hazard. And by the way, they said cost, while it can be considered, should be the last thing considered. They will not accept, they said, cost as being the only reason why you don't want to do what is an option that they may see as possible. And on top of that, they added a hierarchy of controls, and industry certainly appreciates hierarchy control. When we prepared the CCPS guidelines on inherent safety, we purposely showed that there's a hierarchy of controls where inherent safety is first order. But we admitted that, in the end, you have a mixture of passive, active, procedural, and ISD barriers to help you. And they admit, yes, that's true as well. But now, for the first time, they're asking you to study that, document that, and require you to implement at least one passive measure or an IST-ISD measure, or a combination together of an active and procedural measure that gives you the equivalent or greater risk reduction of a passive measure. I don't know too many people that have a formula of exactly how effective is a passive measure, and not all passive measures are all encompassing. There are passive measures that are traditional in the industry, insulation, spacing, layout, you name it, fireproofing, that don't necessarily eliminate the hazard. So I think that's going to be one of the tough issues. We think that this is going to cause quite a bit of discussion. There's a lot of things that are going to create work. First off, the difficulty in documenting what is sufficient evidence to demonstrate that you did this well, and certain things were not practicable, and this is the reason we didn't implement it. There's no guidance as of this time. You can read the preamble and get a little insight, but we're fully expecting, and EPA said, that their guidance will be eventually following. And they're giving us 3 years to work on all of this. That may be an insufficient amount of time for some people that have a lot of work to do. But nonetheless, we're anxious to see what they're doing. And honestly, at this time, the best advice is all we can offer. You have to figure out how to document practicability. And we certainly think that it's going to require, for simple things, very little documentation, but it has to be there. And for more complex issues, it could be quite a bit of extraneous information. One thing we're not sure of is when they say that you have to have a passive, active, and procedural measure, can you take credit for what you already have? We think it's only reasonable. I mean, otherwise, what they're telling you is follow a process and add icing to the cake, even if there's already icing on it. So we're not particularly convinced yet that that's what they really mean. If they really mean that, I would expect industry to push back on that, especially if the risk is particularly low, because otherwise we're adding inherent safety and passive measures on already significantly reduced risks. There's a few workflows you're going to have to figure out, like how do you do an STAA study? I would recommend the CCPS guidelines book where we anticipated these regulations, and also look to guidance from other places like the New Jersey TCPA guidance and the Contra Costa County guidance. But you have to follow what they're actually asking you to do here, which is a little different. In addition, we don't expect that an average PHA team, while they said you have to have someone knowledgeable of the process, they don't necessarily have expertise in all of these aspects. This is complex, and the more challenging the technology is or the issue is, the more difficult this will be. In particular, like environmental factors and what's called risk transference, where squeezing a balloon and I get something that I didn't expect happening over here that creates a risk transfer. An example would be, okay, let's minimize the on-site storage and let's go to just-in-time deliveries. Well, who is exactly able to factor the benefit and risks of that? It's going to be difficult. They are not requiring you to implement the identified ISD measures, which is really interesting. But this is the first time that any federal, state, or even local regulator has required any sort of risk reduction be implemented as a result of the hazard evaluation, i.e. the passive and active plus admin equal to passive. So that is going to be very, very interesting. Mark, would you like to speak to the last part about documentation, please?
Yeah, thanks, Dave. Again, this is an area where obviously documentation is going to be key. Your team is going to be looking at different alternatives. There's going to be a lot of back and forth on that team on what's the suitable alternative, what's the commensurate risk reduction that's achieved with each, and how you ultimately document the strategies that you consider and the strategies that you ultimately decide to implement is going to be key, because obviously in the future, in the context of enforcement or after an event, you're going to have very close scrutiny of that team's work, to the extent that the agency or plaintiff's attorneys are going to be attempting to look at that and say, you knew of the hazard, you had identified alternatives, and you failed because you didn't implement them. So certainly this is an area where I would anticipate in-house legal counsel and outside counsel are going to be more involved in how this initially gets set up, because how you document what you're doing, and more importantly, how you document what you decide not to do, really does have follow-on consequences. Let me answer just one quick question that I saw that came through in terms of whether or not compliance with the state requirement would be sufficient. It's just not clear. I mean, certainly you need to map very closely what does New Jersey require versus what do the feds require. And really, until that guidance comes out that Dave spoke about from EPA, it's going to be hard to ascertain whether or not there's an exact match.
Very good. Yes, I mean, we've done many, many inherent safety studies, and they can be very beneficial. But when it's implemented quite like this, and if people aren't prepared for this, there's going to be quite a bit of confusion, I'm sure. And they're not telling you how safe is safe enough. Also, they're not, they say they're only implying that you should study it, but you don't have to implement it. So while that's not new or unique, and sometimes it doesn't cause any issues, it definitely is laying the groundwork for a future, I think. Mark just mentioned the legal ramifications. There's also technical ramifications. If you identify these things, possibly there's work to analyze them and to see if they really make sense. There could be some simple things that actually make sense, and there could be some highly complex and expensive and difficult business decisions that have to be made. Okay, Mike?
Okay, the next topic relates to the analysis of RAGAGEPs. What EPA has said in the new rule is that you have to document the differences between the RAGAGEPs that were used to design and build the equipment originally and the current editions of those RAGAGEPs. And this is, I think, one of the most important parts is that gap analysis has to be made available to the public. Now, that's part of the information availability subpart of the new rule, not the PHA part. But providing that information and fostering a debate in the public about, exactly, the status of your facility with respect to the RAGAGEPs is going to be an interesting task. Now, one of the things that you need to understand about RAGAGEPs is some of them you're grandfathered for. For example, if you built your plant in 1980, you built the towers and vessels, so forth, to the ASME boiler and pressure vessel code that existed at that time. Assuming that the service conditions haven't changed, a new version of that RAGAGEP would not require you to go back and modify those pressure vessels or towers or whatever, or replace them. But other RAGAGEPs that are issued by industry do sometimes add additional safeguards, add additional protective measures, increase the level of safety. And those you'll have to pay a little more close attention to. The should versus shall language or equivalent language is going to be important here. Although unlike OSHA, EPA is never in writing ascribed to the definition of shall and should that is common throughout the process safety community. So we'll have to see how that part of it works out. But this is a requirement that you have to do, but the PHA element itself doesn't exactly say how you're supposed to do it. And you got to make that available to the public once you're done with it. So this is part of the information availability provision, as I said, not the PHA element itself. How would you have a gap analysis that you're going to make available to the public without doing something during your PHA, or doing a separate analysis, perhaps? It's maybe part of your mechanical integrity program, or assembling this information, this gap analysis, perhaps when you're compiling the process safety information in advance of your PHAs. That's another opportunity for doing that. It's not clear when you should exactly do this, and perhaps EPA will allow you to pick and choose exactly when you're going to do the analysis, but it will have to be done. And like they pointed out for STAA, typical PHA teams would not have the detailed design expertise, most of them anyway, to evaluate the applicability and the interpretation of the relevant RAGAGEP. So they're in general, fairly complicated documents, and a typical PHA team might need to be supplemented in order to do it during a PHA. So maybe a separate analysis is a better idea. We're going to have to see how exactly what the EPA is going to accept. Next.
Mark, do you believe that this will cause additional legal issues? The ragged gap, as challenging as that can be?
I do, and I think it's one of those areas that other than the ISD, this one has the potential to cause industry a lot of difficulty depending on how aggressive EPA wants to be in pushing on it. We were very involved in the Philadelphia Energy Refinery incident, and even in the context of that event, which happened in 2019, EPA and CSB, for example, were suggesting that changes in material specifications, ASTM standards, should have triggered a retroactive look back by the owner and operator of the refinery at the time of that change to determine whether or not what was in the unit was the right steel. And here, in the U.S., we really disfavor what we call the retroactive application of requirements. The government can set a requirement, but typically you can't reach back and punish previous conduct. And it becomes really complicated in the context of a design standard, because obviously the facility would have been built and constructed at the time in accordance with set design requirements, as Mike alluded to. And now all of a sudden we will have to watch carefully whether or not EPA is coming in and saying, look, there's, because of a change in the ragged gap, a change in industry knowledge and experience, there's now a need to go back and do something else. So Dave, this is an area where we're going to be watching closely.
And the availability, inviting the public to join that debate, is going to be an added feature that's going to complicate everything.
Very good. I'll move on to incident investigation. And, the existing RMP that up to this point had incident investigation and the need, there was a definition of what constituted an event. And they had a similar definition for the reasons to do an investigation, including those actual incidents and also implied about near misses. But here they failed to add a near miss definition. So we still have some vague concept there about exactly what it constitutes a near miss. They did say that the investigations now must include 3 distinct things: an initiating event, a direct and indirect contributing factors, and root causes. So they're emphasizing, rather than just simply identifying the causal factors, as it used to say, that there should be a root cause analysis using recognized investigation methods. And most safety professionals would condone that. But now there's a lot of expectation. It's going to be interesting to me if people are, say, only documenting simply that they had a near miss and then doing root cause on more extensive incidents. Is that a gap? Will they now be expected to do a root cause analysis on even these near misses? They have 12 months, although you can extend that under certain circumstances with the implementing agency. Don't forget, the implementing agency is not always the federal EPA. In certain states and localities, there's others that have authority. Now, the root cause analysis methods that are to be used are not necessarily approved or described at all. It's really up to your decision. This is not uncommon in regulation that's performance-based, but it's a common component of EHS and PSM-related incident investigations. There's tools out there. We're fairly certain it's not the tool so much as the depth of the analysis. You're supposed to reach back in and see what was the failure of the management system, not just a simple, the valve, was left open by mistake. Is it the training? Is it what have you? And so that's what they really mean by root cause. They do have a definition of root cause. And so, while they didn't define near miss, this could be some extra work for certain people. Anything to add to that, Mark?
Yeah, here again, and I'm going to sound like a broken record on this in connection with the issue of documentation. Note that change to the definition of root cause and the fact that it now incorporates this concept of a correctable failure in management systems or process designs. And so again, your incident investigation team is going to need to be very thoughtful in terms of how they frame these issues. And again, just because the agency includes that concept in its definition of root cause doesn't mean that that now needs to be the language that you use. And obviously, I would be counseling clients that your incident investigation reports should now not be saying, we've identified the following correctable failures. The concern being that, again, this notion of a correctable failure sets up the idea that it was a fixable issue and that the failure to fix it post-incident could be the basis for liability. And so again, just another area where we're going to want to be thoughtful in terms of what do we say, how do we say it.
Excellent point. Mike, I'll move on to audits.
Okay. The changes to the compliance audit section of the RMP rule is probably, along with STAA, the most extensive from a technical viewpoint. EPA has adopted a requirement for third-party RMP audits. Now, that doesn't apply across the board to the entire RMP community. Like STAA, there are some criteria. Those criteria are a third-party audit will be required if the facility has experienced an event that qualifies for inclusion in the RMP 5-year accident history since the last audit, or the RMP implementing agency, and I'll define that in a second, demands a third-party audit because they reviewed the last one that was done and the competency or impartiality of that previous third-party audit was called into question for some reason. Now, who are the implementing agencies? Well, for most of the RMP community, it's going to be federal EPA. But in 9 states and in 4 counties in the United States, the EPA is granted implementing agency status to enforce the RMP rule to either the state or the county government. Okay, so now what are the requirements if you have to do a third-party audit? And there's 2, in addition to some of the reporting things I'll get into in a second, there are 2 main areas that you're going to have to face with respect to third-party auditor competency and impartiality. And the first one I want to talk about is competency. A third-party auditor has to be knowledgeable with the requirements of the audit element of the final RMP rule. A general requirement. If your third-party auditor has been doing PSM and RMP audits for a while, they probably are knowledgeable about the regulation. They have to be experienced with type of facility or stationary source that is being audited and the processes being audited. Again, if they've got a long-standing history in the auditing of PSM and RMP, they should be able to show that fairly easily using typical types of resumes and other standard company type of documentation. They have to be knowledgeable in the applicable RAGAGET practices, and that may be a little more difficult. But somehow they'll have to show that they understand the RAGAGETs. The main issue with respect to competency of a third-party auditor is that they have to be trained and or certified in the proper auditing techniques. Note the word "or" there. So they can be trained in RMP auditing, or they can be certified in RMP auditing. They don't have to be both. So what is going to satisfy them? Well, we'll see, but there are certifications. I'll describe them in a minute. Training or experience may suffice. We'll discuss that in a minute. So the next part of this, beyond competency, is independence and impartiality. And there are several criteria, several bars that have to be met here with respect to impartiality. First is the auditor, except for payment of doing the audit itself, can derive no financial benefit from the outcome of the audit. In other words, we can't be pointing, fixes, either RMP program fixes or hardware fixes at the third-party auditor's company. Retired employees are okay if the only attachment they have to the owner of the facility is a retirement program or an employer financed health insurance program, something like that. But any other financial tie would be disqualifying. The audit team leader, as a minimum during a third-party audit, must be independent. But the remainder of the team can consist of either third-party audit from employees or personnel from the facility being audited. So it can be a mixed team. It doesn't have to be completely third-party, but the audit team leader must be. Third-party audit personnel cannot accept future employment with the owner of the plant for at least 2 years after the final audit report has been submitted. So there's a window of not allowing a revolving door sort of situation. They did remove one part of the draft rule that said you couldn't be a third-party auditor if you had done consulting work in the 2-year window prior to the audit. That provision was removed. All third-party audit personnel have to sign and date a conflict of interest statement documenting that they meet the independence criteria. Okay. Next slide, please. Auditors, third-party auditors, have to have their own written policies and procedures on how they're going to do the audit and how they're going to address the competency and impartiality requirements. Next slide, please. So what are the responsibilities of the third-party auditor? Other than the typical things, and they're listed here: manage the audit, determine who audits what, prepare the report, certify the final report, and provide a copy to the owner and operator. These are typical client and auditor types of relationship responsibilities and roles. But the one that's important, and I've highlighted it here on the slide, is where there is an audit team, not a single auditor, the audit report has to document the full audit team's views in the report. So if there is one auditor who is, just can't be convinced that the findings are the way the rest of the team believes they should be, and is, just maintaining that position, that has to be documented in the final audit report. That is a brand new requirement, and we've never had anything like this in process safety auditing before. Next slide, please. The responsibility of the owner in a third-party audit, again, typical things: certify the report, generate the corrective action items, retain the last 2 compliance audit reports. Nothing new there, but the part that is new is that the owner-operator of the facility has to immediately, and they use that word, immediately, submit the audit report to the board of directors or a comparable body or an individual if it's a solely owned company, whether or not they were conducted by third parties. So the board of directors or the owner, the actual owner of the company, has to receive the audit report immediately. Now, we don't know exactly how immediate is going to be defined, but I'm guessing that within a couple days or some very short period of time will be what EPA expects.
And Mike, if I can interject, and
please.
Here, anticipate that your organizations, from a corporate governance perspective, are going to be looking at this issue very carefully. I was involved in the Baker panel that looked at the issue of corporate oversight of process safety after the Texas City disaster. Certainly the panel had strong views in terms of the role for the board of directors, but the notion that board members are going to be receiving individual audit reports for all of the facilities that an organization might have, there's just going to be an actual question in terms of whether or not boards are suited, positioned to review and assimilate that information in a meaningful way. And certainly we're going to be talking with clients about how do you set up a process where, to the extent that the board is getting these reports, you also have management almost contemporaneously making a report on what's going to be done to address the recommendations. because the last thing you want is the information going up without, again, that concurrent explanation from management about what's going to be done to address an identified gap. But this is really EPA inserting itself into corporate governance in a way that to my knowledge, it has never done before.
Right, and that's a new thing. You're right. Okay. So this documentation of the differing opinions among auditors, if they exist, and I'm sure audit teams are going to work really hard to reach consensus so that everybody can live with the results. But if they can't, how this is going to be documented, and how the different opinions between internal auditors, if you have them, how that's going to be reconciled and documented is completely unstated in the regulation. And this is going to be a sensitive issue going forward on audits if those differences of opinion exist. They've set up a situation where this is like the Supreme Court, and dissenting justices can file their own opinions. So I'm sure Mark can talk about that aspect of it, but nonetheless, we're going to have the same thing on third-party audit terms. Maybe we'll see. There's no set criteria for the training and/or certification requirement that I mentioned a few minutes ago. There are actually formal certifications that are available. Certified Process Safety Auditors, that's the Board of EHS Credentialing. BAC, the Board of Environmental Auditor Certification, also has a certification that's available. CCPS has the Certified Process Safety Professional certification. But those are not required. The third-party auditor can be qualified based on training. So if they don't have certifications, then you got to be able to show how they were trained. What is left unsaid is an appropriate level of experience doing PSM and RMP auditing sufficient in lieu of formal training. I hope it will be, because there are a lot of experienced auditors out there who've done this for a long time. But we'll see how this training and/or certification enforcement works out. I've already talked about the 2-year window prior to the audit. They removed that requirement, so that's good. And now a new requirement: auditors are now required to certify the audit reports. In the past, it was typically not the auditor, but the owner-operator of the facility itself certified the audit report. Now the auditors have to do that as well. So that's a new requirement. And there's certification language that goes along with that. Next slide, please.
Okay, well, we'll go through the rest of these briskly. Did you want me to take this, Mike, or are you?
No, I've got this one, but
okay. Yeah, we've got
employee
about
participation. Well, yeah, we're gonna have to speed up a little bit. Employee participation. It's the same, employee consultation language as the original RMP rule, and for that matter, that's in the PSM standard. But there are a few added provisions. The first is employees can offer suggestions on about why a recommendation should be adopted or declined, or whether alternatives should be taken. So they can offer that opinion when they want to. Facility has to issue an annual written or electronic notice, maybe email, like an e-blast, to its employees and their representatives, indicating that the plan is the employee participation plan is available for review and how to access it. The two most important additions, however, involve emergency shutdown. The employee participation element now has an explicit emergency shutdown authority for the operators on duty. Prior to this, it was just the requirement to include emergency shutdown procedures in the SOPs. Now it's an actual authority. Additionally, anybody can make a recommendation to the operator in charge of an operating unit that the unit be shut down completely or partially based on what they believe is a potential for a catastrophic release. Now, that's a recommendation. That's not nobody can walk into the control room, for example, and demand that the unit be shut down. The operator in charge would have to concur with that recommendation. Those two are new. A general stop work authority has not been included in the regulation. There was one in the draft regulation. So the stoppage of any work, not just the emergency shutdown, has not been included in this regulation. Again, emergency shutdown authority is now explicit. There's no criteria for making suggestions about how to do that or how to even respond to those. Would an email to somebody suffice? Would something simple like a suggestion box suffice? We don't know. We'll have to see how they do the enforcement before we can have any further insight on that. Next slide, please.
Okay, I'll cover emergency response. Now, given that that's a key element and a difference of the public impacts, and for both environmental consequences and life safety consequences of the public, between the RMP and the PSM, they're particularly interested in this. You have to develop and implement procedures for informing the public and the appropriate agencies about your releases, and also provide your first responders release information in order that they can develop emergency response plans and so forth in coordination with you. And I think a lot of that probably originated from the West Texas incident where there were firefighters killed and they were uninformed. And so that's more likely the nature of that. Drills and exercises are at a minimum field exercises by March 2027. I can't even count that high. I thought this was kind of odd that they would give you this much time. But it is a caveat, unless local responders indicate the frequency is infeasible. And I presume that means one way or the other, but they may insist on something sooner. Perhaps a fire marshal has some authority for that, but more likely, at a minimum, where you have this requirement, probably and practically, you might want to do this sooner depending on your risks. Evaluation reports have to be produced within 90 days. So we don't have anything here that changes the basic HAZWOPER requirement, which said that you can make a choice of offensive firefighting and release mitigation or not. So you can be a responding or a non-responding facility. Of course, we all respond to an emergency, but in terms of offensive suppression or what have you, there's a big difference between the requirements under HAZWOPER, and you're still allowed. This doesn't affect that at all. There's also emergency response requirements from the RMP prevention program. And there's places in the 2019 reconsideration rule that include, for example, the annual coordination between covered facilities and local responders to at least make an attempt to do this. Annual exercises, notification system, particularly if you have like public address system or a fence line monitoring system, which they're very sensitive to. Tabletop exercises are required before the end of 2026 and every 3 years thereafter. And it gets those field exercises that have the 10-year interval. So there are some people, and they commented in the preamble, there were like 56,000 comments for EPA to consider. And some people asked, well, what if they can't get coordination response? There's a lack of cooperation or what have you. Maybe they don't have the time. Maybe it's a volunteer department that doesn't have the resources, or there's no money for them. You can maybe expect this might happen. And what if your good faith efforts, there's some difference there for providing this. What do you do? Certainly you make an attempt and you do everything you can, because in my opinion, you're very dependent on those first responders to take care of these offsite impacts. And so I would take care of them the best I possibly could, regardless of the regulation. Lastly, information availability, and then we'll close out. We're going to go a couple of minutes over. The EPA is proposing to allow the public, which is a new concept here, to request information. And this is beyond their FOIA, Freedom of Information Act rights. But this one is codified in this regulation. So if you're within 6 miles of a facility, you can request this information. Now, if you go through this information, some of it is available in the RM plan anyways, but some of it is not. And so, you would have to prepare yourself and look at the regulation in the time we have left to be certain that you're prepared to share that information, make sure the quality of it is good, make sure it's accurate and so forth. Because now it's going to be requested, we imagine, much sooner. It requires that, recommendations and justifications from all of these various evaluations, some of which are very new, have to be shared if they were declined. This is, I think, one of the more significant things. It was already mentioned, but you're going to have to explain yourself as to why you didn't accept these recommendations. And to my knowledge, EPA did not include now OSHA-like language, which some people use, which said, well, these are the reasons why. They only gave you under the STAA reasons why you might say it's not practicable. The information has to be in English, but also 2 other commonly spoken languages in the population area affected. The bigger your area is, you're going to have to figure that out and what's fair and maybe do something more if you had to. So for some companies, what we're fully anticipating is that this will be a bigger deal. For others, it's almost no action whatsoever. They'll have the obligation, but they won't have the activity. But for certain that are in, let's say, more adversarial relationships with the public, maybe they've had a poor accident record, this could become quite a tail wagging the dog of this regulation. They also have provisions for increased public access and more online. They're building a tool that if you live within that region, that you're able to then have this information. We really hope that this doesn't get abused in any kind of way, because there was a lot of concern. In 1999, there was a CICIFRA regulation that restricted what originally EPA wanted, which was the wide open sharing of all this information, including the worst case analyses from the offset consequence analysis and the alternative releases, which are still restricted under the CICIFRA regulation. So we're just hoping that people don't use this additional information in the wrong ways. I'll add this, and then we'll probably have to close to be on time here. The effective date of the final rule, May 11th, early this year, but we do have time, like 3 years in some cases, to make these improvements. That's going to come up rather quickly. You may recall in the early days of PSM, we had like 5 years, and for some people, waiting was not a good idea. So we would encourage you to start planning now. Think about all these things, weigh what matters to you with your situation, and figure out a strategy for compliance. And it may involve training, it may involve consideration of STAA implications or any of these other implications. But the compliance date is going to come rather quickly for large facilities, and many of the 324 and 325 NAAQS codes involve such facilities. So this is our best advice at this time. Happy to entertain any other questions, or Mark, any closing comments, please, on what we've just covered in the past couple of minutes?
Sure, absolutely. I just recognize that EPA has identified enforcement of the chemical accident prevention regulations as, in effect, an enforcement priority for fiscal years 2024 through 2027. So EPA has already said that one of their enforcement initiatives is going to be on this specific topic. Certainly anticipate that there's going to be a lot of interest in a facility's plan to come into compliance. And to the extent that you're the subject right now of an ongoing inspection, ongoing enforcement, the agency can always, and we've seen them do this, try to require an earlier implementation of a requirement as part of a CAFO or a judicial consent decree, where they're basically saying this is injunctive relief that we believe you should commit to as part of the settlement. Only other comment, we're going to have to carefully watch all of this. I mean, this is just the first salvo in terms of the rule being issued. We saw it with the Obama RMP revisions. There's going to be judicial challenges to this rulemaking by industry organizations, let alone what happens if Trump Part 2 occurs in terms of what his EPA is going to try to do with rolling back aspects of this. And so certainly be aware of the 3-year compliance deadline, but recognize that this is going to be shifting a lot based on developments.
Okay. Well,
Dave, I just want to make one more quick point, and they're on this final conclusions slide. If the RMP rule survives as we just described it, this will be the first time that the PSM standard and the RMP rule, at least the prevention part of RMP, will diverge, which now starts to increase the amount of work, different procedures, different activities that you may have to engage in to satisfy both regulations. Also, this represents the first time that they have used the worst case and alternative release scenario results other than to simply collect the data and tabulate it. They use that data to determine the 1 mile distance criteria for performing an STAA. So that's the first time they've used it technically for any purpose at all. So what future uses of this data can we anticipate? And then finally, we already made this point, but it's worth repeating. In the STAA, this ISD, passive, active, and then procedure requirement. This is the first time any process safety regulator has required mandatory risk reduction measures as a result of doing some analysis required by a regulation. This is a major departure from previous rulemaking in process safety. So that we think is a pretty big deal.
Well, I want to, for one, thank you on behalf of Mark Farley and partners and AcuTech for your participation. I know you may have questions. Please send them to, as Stephanie will tell you, to contact@acutech-consulting.com, and we will respond. And we're happy to talk with you at greater length. In addition, she'll tell you about how we thought this was such a significant topic that we're going to hold 2 additional seminars on special topics. Steph?
Yeah, so thank you. I want to express our thanks to each and every one of you for joining us today. Your active participation in our poll and the questions made this webinar really engaging. As Dave said, we will send out a link to the recorded webinar once it's available. Feel free to revisit the content, share it with your colleagues, or delve deeper into the insights provided today. If you need a PDH certificate, email us at contact@acutechconsulting.com. I'll put that in the chat again. We are taking the questions out of the chat as well, so we'll get in contact with you. Part 2 of this webinar will take place on May 1st at 2:30 p.m. Eastern. We will send out an email to the group that it was on this webinar, so you'll have a link to register for this. It'll also be on our LinkedIn and our website. And for those of you who submitted questions, like I said, that we couldn't address during the sessions, don't worry. The team will follow up with you individually. Once again, a big thank you to everyone for being a part of this conversation, and we look forward to connecting with you again in future webinars.